Good afternoon, everyone. As you know, the subject of this press conference is Senate Bill 180, which is set to take effect on July 1st, and an Office of the Attorney General opinion just released on that subject. I'm joined today by the Solicitor General, as well as by Representatives Barb Wassinger, Representative Tori Marie Blue, and Senator Renee Erickson, all of whom carried SB 180 at various stages of the legislative process. As you may know, the issuance of an official opinion by the Office of the Attorney General is not typically accompanied by a press conference, but SB 180, which is the subject of today's opinion, has been the topic of previous press inquiries. It has been the subject of much discussion in the media. In addition, a few local officials have made public comments about SB 180, and some of them have been incorrect or may reflect a lack of familiarity with what the law actually does. So for all of these reasons, we decided that it would be appropriate with this particular Attorney General opinion to do a press conference and answer any inquiries you might have when the opinion is issued. The opinion addresses three specific topic areas. They are driver's licenses, birth certificates, and correctional facilities. The opinion speaks for itself, and if you haven't been provided one already, you'll get one at this press conference as to what the conclusions, the legal conclusions of the office are in all three areas. But I will briefly summarize the conclusions in the three areas right now. So let's start with driver's licenses. SB 180 requires that a driver's license issued by the Department of Revenue, or KDOR, lists the licensee's biological sex at birth. This is an ongoing requirement governing a data set that is constantly changing. Whenever we take our latest picture or gain a new address, it is a constant ongoing database. So if KDOR has previously modified a driver's license to list a sex other than the person's biological sex at birth, SB 180 requires KDOR to restore the driver's license data set to its original form. SB 180 does not require the licensee to surrender the license that was the actual card that was issued that reflects a different sex other than the person's sex at birth. But it does require the agency to restore the data set back to its original and place that information on any future driver's license card that may be issued to that person. This is similar to when a person changes address. You may still use your driver's license with the incorrect address on it, but the new driver's license that is issued when your current license expires will reflect the correct address. Birth certificates. SB 180 also specifically addresses birth certificates and requires that the Kansas Department of Health and Environment, or KDHE, list a person's biological sex at birth on the person's birth certificate. This too is an ongoing requirement. So if KDHE has previously modified a birth certificate to list sex other than a person's biological sex at birth, SB requires KDHE to restore the birth certificate to its original form. However, here too, SB 180 does not require an individual who obtained a change of sex on his birth certificate to surrender that piece of paper. It does require KDHE to change the data set and reflect that change in any subsequent paper birth certificates that are issued, and they must be done in compliance with the law. Finally, correctional facilities. In this area, the impact of SB 180 is more limited. By its terms, SB 180 only addresses state law and state rules and state regulations. The placement of inmates at Kansas correctional facilities is informally decided by state policy. It is not formally stated in our statutes or in our regulations. As a result, most are not affected by SB 180. However, there is one exception. One facility is affected. It's found in KSA 75-52-134. That specific statute requires that the Kansas Department of Corrections house only biological females in the specified portion of the TOPEKA correctional facility that is addressed in that particular statute. So the correctional facility placement of inmates is affected only with regard to that specific wing of that specific facility. Otherwise, SB 180 does not affect the placement of inmates as SB 180 is currently worded. With that, I'd be happy to take any questions, and of course you have the representatives here if you want to address any questions to them. Yeah, John.
So walk me through this business about birth certificates. driver's licenses. So the agency has to go back into its records and make corrections. If I am the person with the birth certificate and I never asked for another one, I still have the birth certificate with the gender change on it. What happens to that record when the state goes back to describing me as the sex I was when I was born?
So, if I'm understanding your question, John, the state agency that issues the birth certificates, vital statistics, they have to reflect the person's sex at birth in the birth certificate data. However, if you were a person who transitioned and got a birth certificate reflecting a different sex, that piece of paper can remain with you. Nothing in the law forces someone to surrender a certificate that was changed. However, the state's data will reflect the original sex at birth. And so similarly, with the driver's licenses, the driver's license database will reflect the person's sex at birth.
And so that amended document, that change of sex that I got and I'm holding on to,
yeah,
that just goes away in terms of the state's database?
Yeah, in terms of the state's database. It will be an incorrect birth certificate, and any subsequent birth certificate would be corrected. But the law doesn't require, surrendering these documents.
Well, that raises an interesting question of, if I need a birth certificate to do something, get a passport, I'm trying to think what you might need it for. I have to go back and get the original one then, because that's the correct birth certificate.
That is true. It's the correct one, and it would conform with any other state-issued ID you had, like your driver's license, or if you were a concealed carry permit holder. That information, although we didn't address that in this opinion, that information is drawn from the same driver's license database too.
But isn't that in conflict with federal law? I mean, in Foster versus Anderson, which you filed something on Friday about that, right?
So what we filed on Friday was a motion for relief from a consent decree, which is basically a settlement. So the consent decree doesn't reflect a ruling of federal law or an interpretation of federal law. So there's no conflict with federal law.
And will you be arguing that yourself, or who are we going to see on that?
Well, usually in a motion like that, you wouldn't see oral argument. The judge could certainly call for oral argument if he wants to, and if that, we haven't made any decision. But typically a motion like that would be just resolved on the briefs.
I am curious about that. You are not a defendant in that case. The defendants in that case are the three, I suppose now the actual state officials who hold the jobs dealing with birth certificates. The governor, just a little while ago, at least her office, said they disagreed with your legal analysis. I'm kind of curious. Walk me through how you get to the point where, if you're not a defendant, you get to jump in.
Sure.
When the governor presumably doesn't want you to do that.
So the statutes of Kansas designate the Attorney General as the presumed attorney representing any state agency that is sued in court. The Attorney General may, if he or she wishes, allow the state agency to proceed with their own counsel, but the Attorney General has the prerogative of being the attorney representing the state. And the Attorney General is also the official who is charged with interpreting state law and representing those agencies if that interpretation is ever challenged. So the posture of the Attorney General gives us the ability to say this is what the correct interpretation of SB 180 is. Now, you said, I don't know what conversation you had with someone from the governor's staff. I don't know if they were disagreeing with our motion on Friday or if they were disagreeing with the Attorney General opinion.
It sounds like they're disagreeing with the motion on Friday. They agree that the way the statement was worded is they agree that the settlement was appropriate.
And certainly members of an administration may have policy preferences on this particular issue, but the legislature has spoken on the issue, and so the governor's staff and the governor's agencies cannot act as if the legislature did not override her veto. They did override the veto, and so the law is what it clearly states.
Is it your position that the consent judgment is binding upon the state agencies, or in KDHE in this instance, unless and until a federal judge modifies it?
That's a really interesting question of law. We believe that state law binds state agencies, and if there is a conflict between state law and a consent decree, which is basically a settlement that the parties draft up, and then the judge just signs off and says, okay, the case is gone, here's your agreement. That state law would trump anything that the parties agreed to at that prior point in time.
So you expect KDHE, under your position next week, that they should, I guess, cease to follow the stipulations of the consent judgment?
Well, in this particular case, out of deference to judges, it is the position of the Attorney General's office, and normally that we would ask, we would ask the judge to make a decision first. Normally, we would not push an agency to be in that position.
How many changes has there been made for the driver's license and birth certificates? Do we have a record on how many changes have been done?
I don't know what the current number is, and in fact, someone in the press reported, I think one of you may have spoken to KDHE or KDOR. I saw the number at 112 last week, or maybe in the last few days. My guess is that's pretty accurate. My staff has been in touch with the agencies, so I'm sure we do have a close number, but I'm guessing it's in that ballpark.
Will that mean any passports in that are not usable?
That's a really interesting question. The passport data, the information that you provide to the U.S. Department of State when you get your passport is usually reflected in your birth certificate, your driver's license, and other identity documents that you provide to them. So allowing where KDHE, pursuant to that consent decree, did for a brief period allow some individuals to change the sex on their birth certificates, that could lead to some inaccurate passports. I'm not aware of any federal statute that has authorized the Department of State to begin changing sex on passports, although I'm not familiar with their internal policies. But it's certainly conceivable that this period where some documents were allowed to be changed, and if those documents were then presented at a post office or wherever the person seeks a passport, you could see conflicting documents, yeah.
If you have a driver's license that shows a gender change,
Yeah.
does the insurance still pay for the rest?
That's a conundrum that I guess the insurance companies would have to deal with based on the contract law that they have with the insurance.
There's a group of people that have all of their current documents that reflect the current status after they've changed those documents. Those documents are still good. I mean, you've already said that they're not going to have to turn in their birth certificate.
Right.
They're not going to have to turn in their driver's license, right?
The driver's license is inaccurate, but it is still sufficient for them to drive, just like a driver's license with your wrong address is still sufficient for you to drive.
So likewise, if I have a passport in which I've changed my gender marker and I go, or I have a birth certificate and I go and I get a passport based on that birth certificate, that's still good, right?
That's a
It
question of
doesn't
federal
change
law.
any of it.
Presumably, the U.S. Department of State would make the decision as to whether their passport is valid or needs to be replaced. That's not the scope of this opinion.
If I take a birth certificate in that reflects the current as I've had it done, that's still going to be good, right?
What you're asking is really a question for a state agency. They would have to decide whether, if a birth certificate is out of compliance with state law, do they request an updated birth certificate? That's not a question of state law, and it's not a question that we address in this opinion.
How
But
does this affect voting? If my driver's license has a gender marker change on it, but now that record is incorrect, but I can hold on to my driver's license, presumably until it expires. I go to vote, I have to show photo ID. Does that affect me at all?
Should have no effect whatsoever on voting. None of our election laws make any reference to a person's sex, and so just like, if a person's weight is inaccurate on the driver's license, that doesn't affect their vote.
If the driver's license, lists me as female, as male, if that's the correct record, and I go in and I'm presenting as female, does it not, for the poll worker, does it not raise a question as to whether I'm the correct person?
Actually, the poll workers are directed to look at the photos, not look at weight, like, oh, you've gained some weight since you last gave. They're really just looking for differences in the way a person appears. And that appearance, by the way, that's a good question, John. Nothing in SB 180 changes the way a person presents himself or herself in terms of appearance. That person can still go to the Department of Vehicles and get the new driver's license present, with a haircut and a visual presentation reflecting a transition sex, that is absolutely permissible, and that would be reflected in the driver's license.
Even a name, like.
Sure, you can change your name to whatever you want, and that is reflected. What's that?
You wore a skirt.
I don't think the photo would go below the waistband,
I
but.
do have a question for the legislators who are here, any one of them who want to talk about this. The focus of the discussions on these bills in the legislature was about facilities. The desire to preserve privacy and safety and that in facilities, bathrooms, locker rooms, etc. Was it the intent to have this be the result with birth certificates and driver's licenses?
Senator, anybody?
Thank you for the question, John. Appreciate it. The purpose of SB 180 was to provide a definition of what a woman is, and that anywhere it exists in current statute, that definition is based on biological sex at birth. And so that was the purpose. It didn't create any new rules or any new rights under SB 180. It was simply to define what a woman is in law.
And why do you think this was necessary? What was the need for this legislation in your mind? Like, why is it necessary to have this definition?
Absolutely. I will ask you, what is a woman?
Well,
What is your definition of a woman?
Well, let's follow up on that, because some people would say, if I have a woman's name, I dress as a woman, I present as a woman, and I live consistently as a woman, regardless, I'm a woman. That's the argument that you get from the trans community. What's your answer to that?
My response to that is truth matters, biology matters. You can choose whatever name you want. You can choose to live however you want. That does not make you a woman, hence SB 180.
Are you saying that transgender women aren't real women then?
I'm saying the definition of a woman, again, I will ask you, what is a woman?
I'm not the one who made this legislation.
And my definition is the one that is in SB 180. It's based on truth, it's based on science, it's based on biology. And that is what SB 180 does. It just spells out the definition of a woman.
I do, anybody else wants to deal with that?
I'm going to give my colleagues a chance to respond.
Yeah.
Clearly, there's a difference between biological sex and gender. And so if you want to dress as a man or woman, dependent on who you are, that's fine. But biological sex is a scientific fact. It's binary, male and female, and there's a definition of women.
Why is this an appropriate field for legislation? You're all conservative Republicans, you believe in limited government. Why is it appropriate for government to intervene in this instance?
The reason I was intervening and wanted to with fairness in women's sports is because Title IX is being erased. Women are being erased in the record books, on the sports field. Now you can be anything you want to. And so women need the protection of Title IX, and we need the protection of SB 180.
I think the Attorney General.
Yeah.
Some cities, I think, are considering whether to make themselves sanctuaries for transgender rights, and saying they will not enforce SB 180 insofar as there is anything for local governments to enforce under SB 180. Will there be any, is your office prepared to take any sort of response if, say, Lawrence says, we're not going to follow this law?
Well, I did allude to that at the beginning of my remarks. For example, at least one county prosecutor said something along the lines of, I won't enforce SB 180 against anyone. And the reason that I think this should be addressed is SB 180 doesn't create any criminal penalties and doesn't impose any obligations on any private individuals. SB 180 is directed to state agencies, so that prosecutor's statement doesn't really make sense. It would be like me declaring that I won't collect taxes for the Biden administration. Well, I don't have the authority to, and no statute tells me I have that authority. So it's sort of like saying I won't do what I couldn't do anyway. Similarly, a city declaring itself a sanctuary city against SB 180 is really pointless virtue signaling. It's saying, okay, we're a sanctuary city, but what does that actually mean? The SB 180 doesn't really affect the operations of a city in any meaningful sense unless the city is collecting data that includes a person's sex. And most, if a city was issuing some sort of card that included that information, then it would affect that in that very tiny way. But otherwise, the cities have been very non-specific about what they intend to do, and that's because SB 180 doesn't really affect their operations in any significant way.
This is a good segue into my question. How does the discussion we heard during the debate was about, again, protecting privacy and safety of women, restrooms, locker rooms, so presumably under this law, if you're a trans person, you can't go into this bathroom in the school, you can't use this locker room in a public facility, and so I'm curious how that actually comes to pass, how you make sure that happens.
That particular question about how it affects school bathrooms and locker facilities was not addressed in this opinion or in the request made by the legislator. So I'm going a little bit beyond the opinion here. I mean, if you look at the text of SB 180, you can see that it does two things relative to school bathrooms. One is it states that the government has a important governmental interest in maintaining bathrooms that are specific to a person's biological sex. That is essentially addressing a legal argument that might be made in the future about whether it's in any way discriminatory to have bathrooms correspond to biological sex. So it gives those schools that opt to have bathrooms reflect one's biological sex, it gives them legal cover is one way you might think of it. The statute also tells schools, insofar as they collect data on a student's sex, that the data they collect must reflect biological sex, not chosen sex if it is different from biological sex. So that's on the surface of the statute. To get into hypotheticals beyond that would probably have to be the subject of another Office of Attorney General opinion, because, go ahead.
No, I'm just curious then, so if I have a student, let's say, born female, now identifying as male, the public school record for this kid needs to say female.
Correct.
Is there anything compelling a teacher then to reflect that and how they address the student in classroom?
I don't, again, not having had the benefit of an opinion with a team of attorneys addressing that question, my initial impression is no, it doesn't affect how a teacher addresses people, because a teacher can address people as Mr. Jones or by first name or any number of ways.
What are you prepared to do if the Kelly administration just simply says they're going to go ahead and continue to allow birth certificates and driver's license to be changed in accordance with sexual identity?
Well, we expect the governor's office and her agencies to conform to the law, just as the Attorney General has a legal obligation to defend every law on the books, regardless of whether I agree with those laws or disagree with those laws. Similarly, the governor and her agencies have a legal obligation to execute every law on the books in accordance with the statutory language. So she has a legal obligation to do so, and we expect her to do so. The governor cannot act as if SB 180 was not passed. She has a legal and indeed a constitutional obligation to comply with the law, so we expect her to do so.
Are you prepared to take her to court if they don't?
If that were necessary, then absolutely.
Going back to the filing, so if the judge ultimately decides that the consent judgment is still valid, what would be the next steps for you in your office?
It's hard to answer that hypothetical in the abstract because as a lawyer, the answer is always it depends, right? It would depend what the judge said in coming to the conclusion that the consent decree couldn't be amended. My expectation is that the judge would allow the decree to be amended. It's only being the request in our motion is only for a fairly small amendment to a fairly broad decree. The judge, frankly, lacks the power to set aside state law. So a consent decree, again, it's a voluntary agreement between two parties. The two parties negotiate it, and the judge just signs off. If state law makes the decree illegal, there's extensive case law that says that decree cannot be enforced. You can't, two parties can't agree to something that is illegal, and then just because there's a judge's signature on it, say, we're entitled to violate the law. So I don't expect that the judge would come to that conclusion.
I guess I'll only ask because obviously you believe that state law supersedes what the judgment was.
Yes.
But
Or it's not a judgment so much as a settlement, yeah.
And you mentioned how at least before the judge decides, you don't want to put KHE in that position.
Right.
You have to make that decision. But if the judge does decide to uphold the judgment, would you then ask KHE to justify by state law at that time?
It would depend what posture the case we're in. If the judge declined to allow the state to allow the amendment of that consent decree, then at that point that would be an appealable decision by the judge, and presumably the state would appeal.
So General, the inmate at the correctional facility here in Topeka that's having the sex change, it's okay for that person, for the woman now, to be there, just not in certain parts of?
Yeah, the way, so yeah, the SB 180 goes to how state law defines male and female, man and woman, and it goes to how state regulations and state rules, formal, written, state statements of law. It doesn't go toward informal policies. And interestingly, our correctional facilities policies are not laid out in state laws and state regulations for the most part. So the one exception is that one particular facility, and it's actually not the entire facility, it's just one wing of that facility. So if the legislature wanted to make a statewide law that would affect all correctional facilities, they would need to write a new law or amend this law to go beyond regulations and statutes, because right now it only goes to regulations and statutes.
What's the difference on that one wing? I guess I don't get what the one wing is.
That one wing is actually addressed in state statute, whereas the other correctional facilities throughout the state are not mentioned in state statute.
The wing being the complex, the whole thing, not just...
No, it's one portion of the complex is mentioned.
One building, and can you say what that building is?
Yeah, I can, I've got a reference to the statute. So that you'll find it, if you want to look it up, it's in KSA 75-52, 134. And that's a reference to the Topeka Correctional Facility. Specifically, you'll find it in the opinion. Okay, I'll find it for you.
It's not a shower, I assume.
No, it is not. It's a wing of the facility.
Okay.
And it is... the statute refers to the part of the Topeka Correctional Facility which formerly was known as the State Correctional Vocational Training Center at Topeka, Kansas, shall be used to confine or house only female inmates having a custody or security classification of medium or minimum or lower, end quote. So that's the only reference in state law to the correctional facilities. And since the SB 180 only goes to state laws and regulations, it doesn't go to informal policies.
Do you feel like you're resolving a lot of ambiguity in this opinion one way or the other? It seems like we wouldn't necessarily be here if the legislature had simply said, this is what you're going to do on birth certificates, this is what you're going to do on driver's license. Maybe perhaps been a little bit more explicit. I guess, how much do you feel like you are reading into the statute here?
None at all. I think the statute is pretty clear. I do think it's unusual that the legislature even had to pass this statute. For thousands of years, or at least in the United States for hundreds of years, the definition of sex was very clear and very simple and understood by all. But that's not where we are right now. So the legislature chose to have our laws reflect biological fact rather than a person's chosen expression of identity. And I think that is a reasonable choice, and in fact, it's a choice that is the most legally defensible, because as these statutes are tested in court and as they are applied to one another, there needs to be consistency in our laws, and our laws should reflect truth, and that's what SB 180 ensures, that it reflects biological truth. A person may have a vision of themselves that is different, but SB 180 reflects the truth.
Let me ask you about that, because if I'm born male and I transition to female to the point where I'm getting surgery to alter my body so that it has a female appearance and in some ways can function as a female body. I guess my question is, if somebody is willing to go through that much trouble, why not just give it to them? Why not just say, you know, okay, you went through all that trouble, legally you can be a woman now.
A person is free to present themselves how they want, to dress how they want, to get whatever their operations they choose, but they are not able to change what their sex was at birth or their genetic code, which reflects that sex at birth. And so the state is simply saying...
I guess I'm being unclear in my question.
Okay.
Interviewed a college student, was female, transitioned to male, grew a beard, bulked up, wears men's clothing. Under this law, that person is a female, and in theory, it is illegal for that person, or it's not allowed under this policy anyway, in a public building to go into a men's restroom. They have to use the female, the women's restroom. But if I'm a woman, what you call a biological woman, right? And I see this person go into that restroom, am I not going to say, hey, wait a minute, that's a man. I think that's a man. What is he doing in this restroom?
So again, this opinion does not go to the issue of restrooms and how they are affected, right?
But they sold this law on that,
Well, but
that it would protect women from having to have these folks in their spaces.
Well, actually, much of the law, about probably about 2/3 of the law goes to this question of restrooms and locker
And
facilities.
about 90% of the debate was over facility.
Right, and the law defines that the school or the state entity or local entity has a compelling important governmental interest in it, and basically permits that entity to allow or exclude people based on their biological sex into a restroom.
Let's say I'm a person who believes in that and wants that policy. I agree with what I heard was going on. I just don't want a legal doctrine, do I? I don't want an argument in court. I want to make sure that these trans folks are not wandering into my daughter's bathroom.
The SB 180 does not empower any private individual to bring litigation against any other individual or against any school because of the way that organization or school maintains their bathrooms and who can go to what bathroom. It does give the school a defense if it is challenged, but it doesn't create a private right of action. It doesn't. It's certainly something I get. Let's imagine your hypothetical case. It's always dangerous for lawyers to wander down a hypothetical, but presumably, if one parent sued another parent or sued the school, it would give them some arguments, but the binding effect is limited. It does absolutely give the school a defense if the school chooses to do that.
I wonder because, for example, under Florida law, let's take Florida for example, very specific. It's trespassing if you go into the wrong restroom and you refuse to leave when you're asked. If you're an educator and you flout the law, your license could be at risk. In other states, Oklahoma, if the school district doesn't do what the law requires, they can lose 5% of their funding. And so I'm wondering if this is going to come up next year for the legislators where there's going to be a discussion of that kind of policy.
I will hand that question to the legislators to answer, but it's not my role to opine on what bills they're going to consider next year. But I will say this: what SB 180 clearly does is define what must be done with respect to birth certificates and driver's licenses. And when one thinks about it, it's eminently reasonable. A birth certificate is a record of what happened on a particular day when a particular baby came out of the womb. It reflects the baby's weight, the baby's sex at that time, the baby's mother, and it is a reflection of an historical event, and that reflection should be accurate. And I think the vast majority of people would agree, regardless of what a person's chosen identity is today, that is a document. That's why we call it a certificate of birth. It certifies what happened. Similarly, a driver's license is not a canvas on which one may paint one's expression of oneself. A driver's license is a state document created by the state using data maintained by the state for purposes defined by the state. You do get to carry that little card that is a reflection of that state document, but the driver's license database is a state database, and the state may use that database in any way it chooses, of course, within constitutional confines, and that state database should be accurate, and in this case, the state has chosen to reflect biological sex as the true meaning of sex within the driver's license statute.
Is that germane to anything the state does?
Can you ask that question in a different way? Is it germane to anything a state does?
The biological sex of birth, is that germane to anything the state does?
Well, yes, issuing licenses, well, here's another hypothetical. Let's suppose that the state authorizes, or a subdivision of a state university authorizes a scholarship for women. That would be something that a state agency would do, and that a state would have to look to the state databases to determine if someone is a woman and truly eligible for the scholarship. A person would not be able to simply declare themselves to be a man and say, I want the scholarship too, I'm eligible. So, I mean, there are many things the state does. Certainly it's a minority of the things there's a lot of things that the state does that have nothing to do with a person's sex, and that's certainly appropriate.
All the agencies that issue.
Yeah, the law covers every state agency. But the impact of the law in these two particular agencies is the most significant, and I think that's why the question was asked. But I'll let the legislators answer the prior question about next legislative session.
Are we going to see a more traditional bathroom, locker room law, like, for example, Florida or Arkansas or Iowa passed?
John, you know we can't predict the future, and if you were to ask me 2 years ago about Apex at this time, I would have no idea what we're going to be doing. So I can't answer that question. It may be up to the chair of those committees, what they are interested in doing, and a lot can change between now and when we come back in January.
What should a private business or school do then if someone's just violating the rule, going to whatever bathroom they choose? Do the police need to get involved? Can they tell them to leave? Which would then probably, like, what should they do?
Well, I mean, if you're talking about under the status quo, a private business has the ability to define its bathroom policies any way it wishes. So in a private, again, setting aside questions of discrimination, a private business must allow, under federal law, a person of any sex, any race, any gender, and any gender identity to be there. But in terms of how the business operates its bathrooms, that's not really a matter of Kansas state law at this point, and subject only to the federal statute that was addressed by the Supreme Court a couple years ago.
And this, John might have touched on this question, so if it's repetitive, I'm sorry. Is it your expectation that the Kelly administration go back and change every birth certificate and driver's license to reflect how someone was born biologically at birth from how they changed their birth marker to?
Yeah, that's one of the holdings of this opinion. And again, changing the data set. It doesn't require the surrendering of the document or the capturing of the document that was issued, but it would reflect all future documents. And again, the number, as I have heard it, although obviously the number changes, is somewhere just over 100. So all of the documents is, it's not a huge number.
Well, just to be really clear, so I'm a transgender candidate, I'm waking up July 1st. What about my life is now different because of this law?
I think very little changes. It just means that changing your birth certificate is not an option, and that your driver's license will, in Kansas, reflect your sex at birth, but you can certainly appear in the picture any way you wish on the driver's license. But the driver's license definition of sex will reflect Kansas state law, and that's biological sex.
And as in terms of protecting women, though, I mean, we know this is supposed to be about protecting women. Do we have any evidence of the transgender community here in Kansas doing any of the sort of things mentioned, like taking scholarships meant for women, or going into the wrong bathroom? What evidence is this based on?
I'll let the legislators join in on that too, but my understanding of the titling of this statute is that it's intended to protect the definition of women as being the traditional definition of women reflecting their biological sex, and that more broadly, biological males appearing as transitioned women, have taken some opportunities that were reserved for women, have, intruded into athletic events that are meant to be.
Here in Kansas, though? Like, in the state?
They can answer that more specifically. I believe there were some instances in Kansas involving high school athletes. And the idea is to protect the definition of women as one that reflects the biological fact of one's either being a male or female at birth. So my understanding is that that's how it protects women, but I'll let legislators talk about that as
So
well.
there's no difference between a man and a transgender woman? Is that what I'm getting from this? I'm just curious.
I'm sorry, I didn't hear your
Wait,
question.
so it just sounds like then, there's no difference in your opinion between like a biological male and a transgender woman? So like basically there's no such thing as a trans woman in your mind then? Or can you just walk me through this a bit more?
Again, I'll echo what the Attorney General said. You are free to live and identify however you wish. That doesn't change the biological truth and fact of your sex. It's different from gender identity, and so that's what this bill aims to do. As far as is this happening in Kansas, my question would be how many women have to lose their opportunity before it's deemed a problem? 1, 5, 50, 100 before you would say, okay, now it's a problem in Kansas, let's do something about it. We want to be proactive and make sure we see it happening all over the country. We want to make sure it doesn't happen in Kansas, and we do have instances of transgender students in CASHA activities, but we want to make sure that we protect the women and the girls'
Well,
rights.
let me ask you, Senator, if I could follow up on that question.
John.
The last question.
The argument we get is that, yes, you can change your appearance, you can undergo surgery, you can do all of these things to make yourself the, me female, her male. And the argument I hear from trans folks is, first of all, not having documents that reflect that identity makes your life just more difficult. You're going to get stopped at the airport more, any of that. And then second, over and over again, they've said, having the documents, the official documents represent your identity is a crucial thing for their mental health. So you ask, how many women do we have? The argument, there's, a dictum is that the solution creates the next problem, like cars were the solution for horses and now they create their own problem. So my question is there not a concern about how this plays out in the mental health, and maybe that concern is a little larger than the off chance that 1 or 2 or 5 women in Kansas might be denied?
Well, I think he's asking, do you have a responsibility for mental health of trans kids?
I absolutely understand that. We have an obligation for mental health of all Kansans, and that includes biological women. And if you listen to the women who have had opportunities taken away unfairly by biological men, I think we need to be concerned about their mental health as well. But I will pose this question. I'm 59 years old. Okay, I don't feel or identify as 59. I can't believe I'm 59. But what happened if some days I feel like I'm 70? Can I go change my driver's license, qualify for Social Security and start drawing those benefits? Can I start drawing all the benefits that go with changing my age based on how I feel? And I can go do all those things to make myself appear younger. So there is, again, you can live and feel however you want. But we are doing this based on biological fact, which is what we need in order to run the state and the state business. Thank you.
I'll just cap that off by saying, again, as I said earlier, the birth certificate is a record of what happened on a specific day at a specific time. It's a certification of a historical event, and the driver's license, according to the new Kansas law, must reflect the truth of one's sex in terms of biological sex at birth. Thank you very much.